Hello and welcome to Absolute Trust Talk, another live streaming edition of our podcast here at Absolute Trust Council. I'm Kirsten Howe, and I'm going to be joined by my associate attorney, Madison Gunn. No surprise, you can see her right there next to me, I think. Today, our episode is called Estate Planning House Edition, and we're going to be talking about, you got it, the house. Most of our clients, not all, but most of our clients own a house when they die, and we have to do the legal work necessary to do whatever it is the client wanted to happen with that house. Now, we have been doing a lot of these after-death trust administrations in the last few years. You can probably figure out why. It's either directly or indirectly related to COVID, and I think Madison and I have mentioned that before, so that's not really a surprise. Most of those administrations involve a house. Most of them go smoothly, but the house presents its own unique issues, and we see a lot of them that don't go as smoothly as our clients would have liked. And we've done a few episodes together, Madison, about where we talked about problems that we see in trust administration, because it's very helpful to hear about those problems so you can make plans to avoid those problems while you're still alive. But today what we're going to do is we're going to try to roll together all the problems that we see specifically with the house. We're not going to hit every single issue because we could talk for hours on this topic, every week and still never cover everything. But we're going to do our best to hit some of the high points. All right, Madison.
Thank you. So a part of leaving your home or a home to family, in California here is the biggest issue is always property taxes. If you've never looked at property taxes from other states, you don't realize how much our property taxes are in California, even if you're under Prop 13, which is what keeps your property taxes low. So the big thing that our clients and most people in California would like to make sure of is if they're passing a property to their children, that the children also receive the benefit of Prop 13 and keeping the property taxes low. Unfortunately, a couple of years ago, Prop 19 was passed, which greatly reduced the ability of a parent being able to leave property to their children without that property tax reassessment. Under the previous proposition of 58, you could leave your primary residence, regardless of value, to any of your children or all of your children, and up to $1 million in assessed value of other real property to your children without any reassessment. And that's assessed value, not fair market value. So if your it's assessed whatever it was in 1950 and the little bit that it's gone up since then. Now, under Prop 19, you're only allowed to leave your primary residence, provided it was your primary residence upon your death and it becomes the primary residence of one or more of your children, and you only get up to $1 million more than your current assessed value. So you're limited. It's not any value. If it's gone up $2 million, you're not going to get a full, retention of the original property taxes. There's going to be a partial reassessment. So that's a big deal. I mean, a lot of people, it's causing some market turnover,
right?
Which I think is the goal, the proposition. Yeah. So that's kind of like one of the overarching themes. But we're going to go through because it could be your primary residence. It could be a vacation home. It could be a rental property that you want to pass on to your family. And in this case, we're kind of going to go through each somewhat scenario. Everybody's in love with the family home, even with its 60 years of deferred maintenance. So, I mean, those are all things to think about. So we're going to go through a bunch of subtopics in there to think about in your own estate plan so that these problems after someone passes away don't arise, because usually it results in siblings not speaking or speaking loudly to each other. So we'd like to avoid that at all costs.
Right.
So obviously, Kirsten, the easiest thing is if everything's sold and checks are cut and that's it. No one keeps the house. It's all sold.
Nobody keeps the house. We don't have to worry about it. We just sell it. As soon as mom dies, everybody gets cash. That's easy. Yeah.
Yeah. Or there's only one child.
Sure.
That makes things a lot easier.
And it's even easier if that one child is the trustee.
Yes.
The trustee and the sole beneficiary, then they can do whatever they want with the house. Fine.
Yeah. Easy peasy.
But and sometimes that happens, but those are not the cases we're talking about here today.
Yeah. So a little bit less easy or a little more complicated is if there are more than one child, but somebody only leaves the house to one child. So meaning there's language in there in the trust that specifically says, I want Timmy to get the house.
Right.
And then what?
All right. So, I mean, that can be pretty straightforward. It might mean that the kids aren't getting the same size inheritance, and that's its own, can of worms. People get upset about that, but there's also a possibility that mom, I'm just going to call the deceased parent mom, there's a possibility that mom said, I want the kids to get equal inheritances, but I want Timmy to get this house. So now what happens?
Yeah.
What are the issues that we see there?
So a part of it depends on what the other assets are. I mean, if the house is worth $1 million and she's got $1 million in cash and there's 2 kids, then that's fairly easy. If mom was still living in her home on her death and spent all her cash on round the clock care and all that's left is the house, that makes it a lot more difficult. Or it's the house and IRAs that typically are outside of a trust. So there could be language in there that makes it equalizing, which sometimes, mom says, I want the trustee to take into account all things passing to my children, even outside the trust, and making sure that, Timmy's share, his 1/2 or 1/3, includes the trust or includes the house, excuse me. But sometimes that doesn't work because there's not enough assets. So one of the options is a bridge loan. And that is, a hard money loan to the irrevocable trust to put cash in the trust, and it's secured by the home. And then once distributions are made, the person receiving the home refinances it to include that. It refinances the hard money loan into a traditional mortgage. That's great.
So they get the house, but it is of less value because we put a lien on it, we put a mortgage on it, but that makes it equal to what the other sibling is getting.
Correct. And one of the things to point out is a lot of times the child that the mom wants to give the house to maybe can't qualify for a mortgage, or, has not been working in 5 years because they've been taking care of mom.
Right.
And doesn't have that, work history that's required in order to qualify for a refinance or the mortgage. And those are all things to take into account.
And right, because that's when it tends to happen, is that mom decides I should leave this house to this child because this child lives in the house already. And there may be other reasons why the child lives in the house, not because they're taking care of mom, but because they really, have not succeeded in the world financially.
Yeah. We hear it as, oh, my other two kids have houses. This one does not. And it's like, well, is there a reason why they don't? Because that might affect their ability to inherit your home, whether it's the mortgage, whether it's being able to pay the tax. I mean, just because the property taxes won't go up doesn't mean that they can still afford that. It still might be $3,000-$4,000 a year. There's still insurance. There's still, upkeep on a house. So those are all things that kind of take into consideration when.
Yeah. So, careful planning can take all of those things into account and say things like, this is what I want. I want it to be equal. If that's not possible, I still want Timmy to get the house. If that's not possible, you can build contingencies in, but it requires, thought, and you got to kind of walk through all the what ifs, which is
that's what I always tell people.
Question.
My job's to ask you all the what ifs. I'm sorry, I'm killing you off early, but this is what we have to, I have to ask all these questions.
Yeah.
because, we want to plan for that. We don't want to have to go to court and be like, oh, sorry, this trust I wrote is ambiguous because I didn't ask the question. You want to, make sure that you go through all the possible paths that distribution, that wish that you want could result in.
Right.
It's kind of like giving the genie a wish, and it's not quite what you thought it was going to be on the other end.
Because you didn't think it all the way through. Yeah. Okay. So house goes to only one child, or house goes to multiple children. House goes to only one child and there are multiple children, and we have to figure out how to make that work. Ideally, we figure it out before mom dies, because it can be a challenge after mom dies.
Yeah.
That's rough.
And then the more complicated is when you just say everything goes to all my children, and you include a house, and there's, 3, 4 children, and
maybe one of them wants it.
Yeah. I mean, there's multiple things. Obviously, the easy answer is to sell it.
Right.
And then that brings up a whole other issue of if there is 50 or 60 years of deferred maintenance, or those countertops are avocado green, or, your linoleum is paisley, you might want to update the house in order to sell it. I know here in the Bay Area, sometimes you don't have to put money into it to get top dollar. So it kind of depends on a lot of things. But what we suggest is if you're going to use trust money to fix up property before selling it in order to get the most bang for your buck for all the beneficiaries, is to do what's called a notice of proposed action, which is getting that letter from your realtor saying, if you put $50,000 in and update this bathroom and this kitchen, you're going to get $200,000 or $300,000 of equity value out of it. Give an estimate from the contractor, send all this information out to the beneficiaries, and let them know, and let them object or consent, and then move forward depending on that. What you don't want is to spend $100,000 of trust money as a trustee and not consult the other beneficiaries in terms of that.
Right. Unless the trust, and I've never seen this, specifically authorizes the trustee to do that. Otherwise, the trustee, when they're doing something that is probably a good thing, but nowhere in the trust do we see authority to do that, you want to get the advance consent of the other beneficiaries.
Yeah. And usually, I mean, it's for their benefit, but you don't know how people are going to react. With the market going up and down, we've seen people react all kinds of ways about what should or shouldn't have been done with their inheritance.
Sure.
I mean, you can't predict that, you become trustee and the next day the market drops. I mean, that's, it's a little bit unrealistic. But if you're the trustee for 3 or 4 years and you're just watching this ride out, then there's something you can do about it. So, and that's usually consulting the other beneficiaries to see what they would like.
Right.
Another option is the buyout. So if one child does want it, then you can do that. They can buy their siblings out. Obviously, if the trust assets are large enough that they get their 25% includes the house, that's fine. Nothing is ever that easy in our experience. So we're not even going to talk about the really easy things.
It's rarely that easy.
So typically, if you're going to buy your siblings or family members out, you want to get that in writing. A purchase and sale agreement typically is what we would write for somebody. The deeds all go in everybody's name according to the trust, and then you purchase it from them through an escrow company. If you're trying to keep the property taxes low, then you can do.
Pointing out that first thing, buy the house from your siblings, that's going to cause a reassessment.
Yeah.
So now, Madison, we're going to talk about the alternative that might work in some cases. Yeah.
And so to avoid that reassessment, it would be a partial reassessment. If it's 2 siblings and you're buying one out, then it's a 50% typically reassessment. To avoid that at all costs, then you could try to do the bridge loan we talked about earlier with the equalizing, where the trust itself takes out the loan and distributes the house subject to the lien, and then you refinance into a traditional mortgage. One of the things with the buyouts is obviously the property taxes only work if it's the primary residence. So if it's not a primary residence, then the bridge loan doesn't
It
matter.
doesn't matter. You don't need to bother with a bridge loan. That's too complex. Just do a purchase and sale. Right.
Yeah. So then typically also if there are multiple children inheriting and then one wants to live there, but they're all going to own it. And you think your kids all get along, just wait. Because if one's going to live there, are they going to pay rent?
They need to pay
rent. It's going to be fair market value rent. Yeah. If it's not, they got to pay it in writing. Who's responsible for maintaining property taxes, maintaining the home, all of those things that need to be taken care of in writing.
Clear, really, really clear. There are things that typically the property owner pays. The property owner pays the taxes. Property owner pays the insurance. Property owner does not pay the occupant's PG&E bill.
Right.
Unless it's been arranged. I mean, sometimes that is part of the rental, but definitely, I think, I'm not a landlord, but they don't pay, the cable bill. They don't pay for the dish on the roof. So it's just, you got to cover all of those things and be really clear.
Yeah. It's just one of those, sure, when you don't want one sibling being the landlord over another sibling, like everybody should theoretically be on the same page with something in writing. And if you have to, use a property management company. It's going to cost some money, but at least it takes everyone's, hands out of it, and it's a little bit more neutral.
Yeah. And I'm just going to say, this is usually a bad idea.
Yeah. Don't do it.
Don't do it. Don't have your children set up to be co-owners of anything unless they actually, for whatever reason, all by themselves choose that. But don't set it up so that that's what's going to happen, because you have no idea how they feel about each other when you're not around.
Yeah. Or how they're going to feel about each other after they own a property together. I mean, yeah.
Or how their spouses feel about each other.
Yeah.
Even more important sometimes.
So in that line, if you have multiple children and they're going to keep it and then rent it, so it's not going to be, no one's going to live there who owns it. Now you have similar issues in the sense that now you have many landlords and one tenant. So they have to figure that out. Who's going to take lead on that? Are they going to get paid for that? Are they, you got to get a rental agreement. It's got to be fair market value, not I'm going to rent this out to my child and aunts and uncles are going to be the landlords, at below market. Property, and that's why I throw in the property management again, so that you don't have family members, trying to figure out who's in charge. That's,
what I have seen in a number of cases where there's a property that, for whatever reason, the siblings are going to remain co-owners of, they will set up an LLC to own the property and make it a true business, all official. We have an attorney who helps us figure out what we're agreeing to, and it's in writing, and we've thought about all the contingencies. So I see that as a good solution for people. It costs some money. You got to go hire somebody to set that all up for you, but it might save your relationship with your siblings down the road.
You have an operating agreement that you can refer back to at all times, makes things easier.
And the person who's managing that business entity, which is what the LLC is technically and legally, they can get compensated, and that can all be laid out, and nobody's surprised. Nobody's feelings are hurt.
Yeah, that's a very good idea. So, of course, the most complicated thing, and which I get asked about the most, so that's, always a little disappointing, is keeping that house in trust forever and ever. Amen. So typically it can be for one beneficiary's lifetime. So I want, Timmy to be able to live in that house for the rest of their life. And then when he dies, or if he chooses to move out, then it's sold and everything is distributed to the rest of the kids, or just it's going to be held in trust for all the kids, long term. So maybe it's that Tahoe cabin, or maybe it's their primary residence and they just want it to be available to all their children. So I guess instead of the pros, what are the pitfalls of that?
Well, you got to have a trustee of that trust, and who's that going to be? If it's going to be one of the kids who's also, one of the beneficiaries, you could get a very strong reaction from the other beneficiaries. I really try hard to encourage people to think about using a professional in a situation like that, where the kids have to, it's kind of like special needs trust. Do you really want one sibling to be the trustee of the other sibling's lifetime trust? It's work, and it puts them in a conflict, right out of the gate. They're in a potential for a conflict. So
yeah, even if they're best friends and you're proud of that as a parent, you don't want to, that is a surefire thing to do that could make them not be best friends anymore.
You're definitely putting that best friendness at risk. Yeah. So, and again, you got to be really clear in the world of trusts. We know what the trust should pay for and what the trust should not pay for. But when you're talking about family members, they don't necessarily know that. So there's got to be some education so that everybody's on the same page. And, if you're keeping the house, you got to be really clear about that.
Yeah. And so if you're keeping the family cabin in the trust, it's one thing to say, oh, they got to pay property taxes, and HOA fees if that's there. But insurance, we're in California. That is a number that is very variable, so to speak. That is a wild card now.
Yeah, it could be a really big number.
Yeah.
And it could be there is no insurance. Okay, now what are we going to do in that situation when you can't find an insurer to write an insurance policy?
Yeah. Or what if there are things that the insurance company requires you to do that, like knocking down trees or clearing land? And I'm pretty sure in California, you can't just cut a tree down. I think you have to hire an arborist and get a permit and do all those fun things. And depending on the species of the tree, good Lord, I don't know. So I would imagine, and if you're on some sort of land or neighboring land that is state land or federal land, that could be a whole other issue. Yeah. So it's important that when we say think these all the way through, and also who's going to pay the water, who's going to pay PG&E, who's going to pay, even cable, if it's the family cabin and everyone is supposed to be able to have equal access, how is that being paid for? Because if you have 4 kids, they might not want to pay for that. It's just like we talk about people who, I'm going to leave my timeshare to my child. I'm like, I don't think they want to.
They don't want that annual fee.
They don't want to inherit that fee. Yeah. So, they might want to use the cabin, but they might not want to, or they might not be able to pay their share of the expenses.
Their share of the expenses. Yeah.
Yeah.
So, one solution is if you're going to hold a cabin, for example, a Tahoe property in trust for your kids, put some money in there too. Hold some money in there to pay the expenses. So there isn't that issue of, okay, every time you use the cabin, it's going to cost you $800.
Yeah.
Or whatever you have to agree to.
Yeah. It's just, that's one of those things. I know there's a lot of sentimental attachment to properties, and I'm not going to I wouldn't knock anybody for that. That's everyone's, their own.
Yeah.
Their own thing. But I think it's when that's the case, and it's hard to value things when it's sentimental value also. So it's very important to discuss all of this together. I think that's, and I mean, all together, not Mom and Timmy, but all of them.
All the kids. Yeah, because you might think, oh, this is what this is what they would want. You don't know.
Right.
Like, maybe they would say, oh, that cabin, every time we go there, we spend the first 24 hours fixing things, and then we get to have our vacation. Maybe they don't want it. So
maybe they'd rather, oh, good Lord, who knows what Tahoe cabin would resell for right now. So maybe they'd rather have that chunk of cash that they can invest themselves.
Right. Right. So for things like that, if you're thinking about making some kind of unusual arrangement other than everything equally to my 3 kids, have a conversation, and actually, even in that case, have the conversation. It's better to have everybody understand what you're doing.
Okay. Yeah, because equally, they might all have different versions of what that looks like. I mean, in its simplistic form, we say, okay, well, if everything's liquidated and divided 3 ways, but that's usually not necessarily what ends up happening. Somebody wants something that's what we call in kind, which is in its original form, not sold. Mm-hmm. So I think with those, they should be taken into account.
Well, and the other thing, sometimes what comes out in the conversation is, well, but you've been supporting my brother for the last 15 years. How is equal inheritance fair in this situation? Shouldn't I get a little bit more? Because
Right. Or you've been paying for my nieces and nephews' college, but I don't have kids.
But I don't have kids. Yeah. How is that fair? Yeah. So having the conversation is the way to at least get that stuff all out on the table and try to address it in the way that works for the family.
Yeah. And as much as we push, and all attorneys probably push, that we have to meet with parents alone to discuss their estate plan, we really do encourage having a family meeting. And that is something that your estate planning attorney can facilitate in the sense that we can ask the questions that you don't know about. Right. People always say, I don't know what I don't know. So we can ask all those what ifs and see what everybody wants. And then you go back and discuss and talk about it, and then have another meeting with your attorney by yourselves to make your decisions.
Yeah, we do need to make sure alone with our clients that this is what they want and they're not being pressured and that they understand it. But that doesn't mean we can't talk to the whole family to help them understand the issues.
Yeah, a lot of times they just have questions. And what are these implications for me? Am I going to be on the hook for this or for that? And, that's typically what everybody always wants to know, so either what am I getting or what am I on the hook for?
What am I liable for?
Yeah. So, I mean, those are all fairly easy questions that we can answer depending on some facts, specific to your situation. And I think having the whole family discuss, make sure that everybody knows the same information. I think a lot of times, parents tell their one kid one thing and another kid another thing. And, we've all seen it. So it's easier if everyone's on the same page.
Absolutely. All right. Madison, I'm going to turn to our audience questions. Just a reminder, when you watch us live, you have the opportunity to put questions in the comment section. If you're listening to a recording or watching a video, can't do that. Okay, question. Can the trustee sell the house even if the other siblings don't want it sold?
Well, I mean, it depends.
It depends.
Yeah. They certainly have the authority to do so. I mean, that's not the issue, but it's not best practices. I think it depends on what the situation is. I mean, unless the trust says something contrary to that, the trustee does have that authority. But back to something that you said earlier, it's always a good idea if you can get everybody to agree to some action that you're going to take. But if it's the only way to make the thing work, the trustee can, and they have to. And here's the thing, your brother can buy it when it goes on the market. So if they really, really want it, they can still buy it.
Can still be a purchaser. That's right. Yeah. So, okay. Another question. Is the trustee required to rent out the house after the parents die?
No.
Well,
Yeah, unless
I
the
mean,
trust
that's
says.
another, it
Yeah,
depends,
it
right?
depends. But typically, in general, no. I mean, it can sit vacant for a couple months. You got to clean it out.
Right. So if the family's plan is we're going to sell this house, then no,
Yeah.
you don't want to get a tenant in there and then have to kick them out in order to sell it. But if you're trustee, you can't dilly-dally. You can't leave it
Right. You
vacant
can't
for
be
3
sitting
years.
there spending trust money on utilities and
Right.
taxes and insurance for 3-4 years, just because you haven't gotten around to it yet. You
Right.
can't, or you don't want to let go of it,
Yeah.
but you're not required to make it productive in the couple months it takes to clean it out and sell it.
And get it on the market. Yeah.
Yeah.
Yeah. Okay. Okay. Another question. I think this is the last question. When the trust leaves the house to one child, does the mortgage also go to that child?
So it depends. Unless the trust says that the property goes without the mortgage, meaning that trust property is to be used to pay off the mortgage, and then the
they get
house
the
is transferred to the child, without encumbrances. Otherwise, generally, the mortgage follows the house, and whoever inherits it also inherits the mortgage. The good thing is at that point, you don't have to qualify for that mortgage. It just
Right.
becomes your mortgage. You only have to qualify if you need to refinance it. So that typically only happens if you're doing those bridge loans.
Those buyouts. Yeah.
Yeah.
Yeah. So that is a federal law that when you inherit a property and it has a mortgage, you get to keep that same mortgage. You have to pay it though, because
Yeah.
they're going to be watching you. And if you miss a couple of payments in a row, then they're going to offer you a refinance, depending on the interest rates, right? But right now, interest rates are going up every other day. So
Yeah.
Anyway, okay. Let me just check one more time and make sure I haven't missed a question. Okay. So I'm just going to mention here, we've been talking about things we see in trust administration and how you can avoid these problems by doing good planning. Madison and I, Absolute Trust Council, is going to be putting on a live webinar event. It's designed for our professional colleagues, our CPAs and our financial advisors out there, on this topic of trust administration. And the date is October 28th. It's 9 to 12:30. We're giving continuing education credits to our CPA friends and our CFP friends. So if you're interested, go to our website, actually the link is absolutetrustacademy.absolutetrustcouncil.com, but you can always just call our office, or you can send me an email. You can send Madison an email, but we'd love to see you there. It's free. You get 4 hours of CE, and you'll hear some horror stories. It's all about what we see in the after-death trust administration and how you can translate that into better planning for your clients. Madison, you want to add anything to what I just said?
No, I think it's great. I think it'll inform everybody how important it is to know what you're doing before you volunteer to be someone's trustee, for certain.
That's another really important point, an important item on the family meeting agenda.
Yeah.
Okay.
Let's see what this entails before you ask if they want to do it for you.
Mom and I are thinking about naming Mary as the trustee. Mary, how do you feel about that?
Yeah, I think it's important to know you can still involve your children without having them be the trustee. And so those are all conversations that should be had with your estate planning attorney.
Yeah. And that's a whole other episode
Yes.
that we could do if we, and somewhere down the road, I'm sure we will. Okay. I think that's it. I'm going to say thank you, Madison, for being here with me and helping me with this. The shows are always more fun when you're the guest, or co-host, I guess is a more appropriate terminology.
So
Okay. And we are always grateful for our audience. Thank you for watching. Thank you for listening. If you're out there with earbuds listening, and we will connect with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.